So we're excited to announce our next speaker, Mr. Noel Gillespie, who is a partner at Procopio. So Procopio is one of our sponsors for this symposium as well. So thank you very much for your support. So he is an expert in advising startups and emerging growth clients on strategic patent portfolio development, with a focus on digital health, health information technology, and various other sectors. Noel brings a lot of experience in helping companies protect their technology to attain market share and premium pricing. So thank you very much, Noel, for being here with us. Take it away. Thank you.
My pleasure. Oh, good. You guys can hear me. So I got the microphone and I got the clicker, which is probably good because I tend to talk with my hands a lot. So this will keep me right here, centered. As mentioned, I'm with Procopio. I hope you've heard of us. We're the largest San Diego-based law firm. We have about 40 people actually working with me, along with me, in the IP group. 40 attorneys and agents, about another 30 people supporting them. And then if you add in IP litigation, it's about another 20 attorneys. So we have actually a pretty big IP firm within the firm. A little bit about me. I'm an electrical engineer by training, spent 6 years as a design engineer doing free space optical communication systems, and then working on the first CDMA handsets for a while. So I have kind of a communications background. I've been doing this for about 20 years. And I've been doing kind of digital health, health IT, those areas for about 15 years, back when it was popular, but there was no market. So it's nice to see the markets kind of coming to bear around sensors and communication capabilities and software and AI kind of all coming together in the med tech space. And we'll look at that in a minute. So what I want to do is I'll briefly do a IP 101. What is it? I think a lot of us think we know, but I find that a lot of us don't know exactly. And it is good to have in mind kind of exactly what are the types of intellectual properties and what do they specifically protect. And then we'll look at how would we bring all of those to bear on kind of a med tech product or application, and then answer the question, why do we care? Why are we doing it? Why are we protecting the IP? I still run into people that say, well, you know, we'll just be first to market. Okay, I guarantee you when the second to market comes, you will be out of the market if you do that. You don't have your IP. Had a client, med tech client, software for a viewer, medical images, say, well, we're just going to do copyright. Okay, it's in-house at a hospital, it's proprietary. Is anybody really going to copy it, or are they going to copy the functionality? Because if it's the latter, you need patents. You can't rely on a copyright. So those kind of questions. So we'll look at that. Why are we doing it? You know, bring it all together. Why are we doing it? Beyond just protection, you know, who are we trying to impress with it? And then if we have a little bit of time, you know, what are some of the other legal issues? And we've heard some of them already, and you'll hear more after me, but that I see affecting our med tech and digital health companies, and a little bit how they overlap with the IP, because they do to some extent. So that's our roadmap. And if you have a question, feel free to jump in. I don't mind. I'd rather answer your questions than just talk at you. So what is it? There's 4 main types: trademarks, patents, trade secrets, and copyrights. You know, things like domain names, that's IP to a certain extent, but these are the main ones. So what's a trade secret? Information. You can see some of the examples and things like, by the way, your contact list, where are you sourcing your products from? Those are trade secrets. But it's anything that derives economic value from not being generally known. And then this is the key part, is subject to efforts that are reasonable to maintain it. I did a presentation again at a hospital. for their innovation program. And kind of an interesting incubator accelerator company out of Chicago was there. And the lead guy was saying, oh, I used to worry about NDAs. I don't even worry about it anymore. You got to perform, you got to get to market. And I said, that's great until you are in the market and they see your software. And I guarantee someone will say, that's great. I could do it for half the cost and have it ready to go in 6 months. And once they've seen what you did, they can do that, right? If someone walks out with not with your code, that would be a breach as long as you're protecting it. But if your employee just goes across the street, takes what's in his mind and starts competing with you, those things are hard to protect. So you want to have your NDAs in place when you're talking to people so that you're not letting it out. We'll see, I have a list down below of other types of contracts where you want to make sure that you're protecting these trade secrets, because if you're not taking any steps to protect it, it's not a trade secret, right? Typically, this was something the states enforced. More recently, there was a federal trade secret act. I'm not sure if I think that's good or bad. Generally, I tend to think those type of moves are bad. But at the same time, unfortunately, the value of patents is kind of eroding due to kind of a concerted effort from our government to make them less valuable. And so trade secret litigation is actually going up. So maybe it's a good thing. Non-competes, again, in California, it's been very hard to enforce for decades. This is what they're talking about now, making national, where you can't really have a non-compete. The way it works in California is, if you're the founder or the CEO and you sell the business, I can get a non-compete against you for a couple of years. The principals, companies in California cannot get that against their employees, which again is problematic, because if they just walk across the street, as long as they don't take anything with them, they can go and recreate what they were doing for you, right? That's the power of the non-compete, is to say, hey, I'm going to train you, you're going to learn our stuff, but then you can't go use it for anybody else for a period of time, right? But they want to that's not the case in California, and they want to make that federal. Trademarks, again, I think most of us are kind of familiar with the trademark. But what the trademark does is this, and this is the part we don't always get: distinguishes goods of one manufacturer from another, right? That's the purpose of it. It's for you, the consumer, right? So if I see a mark, right, the apple with the bite out of it, I know who made that product. I know who to complain to if it doesn't work, right? I know who to go to if I want my money back. If somebody else is making computers and put the same or similar mark on it, well, now I'm confused. Who do I go to complain, right? It's for the consumer to identify the source of the goods. And so what I get a lot is people say, hey, we want this trademark. Okay, for what, right? I mean, the key to a trademark application is what are the goods and services that it's going to be associated with. And then what we want to do is make sure it's available for those goods and services, right? What you don't want to do is brand everything and then find out somebody else is out there with a similar mark for similar goods. So you do want to try to clear it. Costs a couple $1,000s usually to do that, but it's worth it. There's the word mark, which would be like Qualcomm, just the word. You just get the word, but then you also get the stylized logo mark. So those are the main ones. There is intent to use for use-based applications. So because it has to identify the source of the goods, you actually have to be selling the goods with the trademark before the patent office will register that trademark for you. But if you're like a startup, for example, and you're not in the market, you're getting close, we can file what's called an intent to use. So it's the same process, but they won't actually register it until you file what's called a statement of use. Hey, we're using it now. Go ahead and register that. So you don't want to go too early, because you can be pending like that for about 3 years, and then you're out of what extensions. And if you haven't filed your statement of use, you're out of luck. So you don't want to go too early, but as you get close to market, you can do the intent to use. Trade dress, I'm going to talk about this a little bit more. TM, by the way, I just had this come up. So once it's registered, you use a circle R. You've probably seen that, but you've seen this too, right? Just a TM. That means it's not registered. When do you start using that? Sorry. As soon as you are actually putting something out in public with something you think is a trademark, right? So if you filed your intent to use, means you're not using it yet. But if you've got like a website, something up where the marks are kind of visible, even though they're not associated with a good or a service yet, put the TM on it right then, right? TM means you think it's a mark. When the government agrees, you'll switch it to an R. And then renewals, you just have to keep in mind that, you know, as time goes by, you do have to keep renewing these and filing statements of use. And if you forget, your mark goes abandoned. So copyrights. So where do I have it written? Original works of authorship extend a tangible medium of expression. That's once I created these slides, I have the copyright in those slides. Boom, nothing else has to happen. I own the copyright in these slides. Maybe Procopio does, because I work with them. But as soon as I fix it, it's done, right? Own it. You want to put this in there, though, to let everybody else know that you consider it your copyright and you intend to enforce that copyright. You don't have to register to enforce it or for you to have rights in it. Why do you register the copyrights? You register it so that you can get into court to go enforce it against someone else, right? You get into federal court, you can get statutory damages. So if it's software, every time somebody downloads and runs the software, that's a use. That's a statutory damage of 10 grand or something like that. So if 100 people download it, you got some money, which might pay for the enforcement. Because a lot of times with software, it's hard to say, well, what are the damages? Like you're looking at like lost profits or something like that. Well, how was what was the monetary damage? But if there's statutory damages, then you have money coming because you registered it. Anything? Oh, work made for hire. So in these agreements, so a lot of these employment agreements, contractor agreements, you have something that says, hey, the company's going to own any IP that comes out of this, right? And you agree to assign it, you know, sign an assignment assigning that IP to the company. With copyrights, for some reason, you have to have specific language that says any copyrights you create are a work made for hire. You have to have the magic language and they have to sign it. If there's no signature or this isn't there, then anything your employee creates for you, you might not own. So that's important to remember. And just some examples. One of the key ones here to keep in mind, websites, those copyright, you want to get your copyrights in there. And then software, you want to put it in there from the very beginning in the software, right? This is copyrighted by whoever. When you go to register it, you have to send 2 versions of the software into the Library of Congress. If it's really long, you can do like the first 15 pages and the last, and you can redact trade secrets out of it if there's something in there where you're like, well, that's a trade secret. But software, you really kind of have to have a program because typically you're doing revisions constantly with software, right? So you're not going to go and file 2 sets every single time. So kind of what's your program for getting caught up? But if you don't do it, right, then anything that's new in there is not registered. You can't get into federal court to try to enforce it. And then the last one, and this is really from an IP perspective, the big one is patents. Just noting that there's 2 different kinds. There's design patents and utility patents. There's also plant patents, but not really relevant here. So design is like the look and feel, right? The shape of this, not the function. right? They could have made this any size, any shape. They chose this, so that look and feel could be the subject of a design patent. And when we have a device, a lot of times we want to look at that. Hey, do we want to file the design on your device, whatever it is? But the utility patents are the one that cover the functions, how this works, right? And that's typically the most powerful type of IP protection. Because like I mentioned, trade secrets can be hard, right, to do. Because if someone walks out and they don't take anything with them, they haven't stolen your trade secrets. But if they go implement the functions of your software or your product somewhere else and you have a patent on those functions, now I can come and say, hey, you got to stop, right? But the key thing about patents too is there's no such thing as an innocent infringement. So if someone on the other side of the world who never heard of you or saw your product or knows what it does, develops their own product that infringes your patent, you still have the right to go say you can't do it. It's not dependent on copying like copyrights. It's, do you have the function that my patents cover? If they do, I can stop you. As long as I, came first, I can stop you. You get to exclude others then for making, using, and selling. Has to be new or novel and non-obvious. So again, this is one of the places where, in particular, the government's kind of pushing back and making it harder to get patents. I wrote an article recently about how the patent office just came out with some new guidance on how you determine if something's obvious. And it's very wishy-washy. Like if one of skill in the art just thought that would be common sense, right? Well, the problem is we don't have one of skill in the art looking at it, right? And how do we know what one of skill in the art thinks is common sense? They write it down on a document and we can look at it and say this, but the guidance tends to try to get away from that and let the examiner kind of subjectively say, well, I think one of skill in the art probably would have thought of that. So those types of things have been going on for a long time, and we react and we deal with them, but that is where some of the problems lie in trying to get these out there. And the other thing I tell my clients all the time is it's not that we're going to be able to say you can't have competition in the market, but hopefully there's some features and functionality, right, that differentiate your product and that your customers not only want, but will pay a premium price for, right? Those are the things we want to have a patent on so that you can go to those customers and say, yeah, that guy's got a product. He says it's just as good as half as much, but it's half as good and not worth what you're paying because he can't have those features and functions you want in it. We have the patents on those features and functions. So that's kind of how it works. And I just, especially if you're in a startup, I just want to go over the timeline. So typically we start with a provisional patent. That's just a placeholder. It doesn't get examined or it doesn't even get looked at by the patent office. Gives you 1 year to come back and file those utility patent applications I talked about. The other thing you have to do, this PCT, that stands for Patent Cooperation Treaty. Once you file, whether it's a provisional or a utility, you have a year to then file something to at least preserve your right to go file in Europe, Japan, China, and get the benefit of your earlier filing date. Typically, that's expensive, that step. Europe, Japan, China, just the fees, just the fee to file it would probably cost at least 15 grand, if not 25 grand, right? So this PCT, Patent Cooperation Treaty, allows you to file something that's called an international application and meet that year for pretty much everywhere. And then it gives you another, well, it's not on here, but then that gives you another 18 months to go file in Europe and China. So 30 months from your earliest filing date before you have to spend all that money to go file in these different countries. The rest of this is just once you file the utility, it takes about 18 to 24 months typically. Really, it takes about 18 to 24 months to even get it examined at the patent office, but probably more like 24 to 36 months to get to where it's granted, issued. And then it's going to last for 20 years from your utility filing date. So if you have a regulatory path, for example, this is more in the life science area, that's going to take a bunch of time where you won't even get a grant until you're here. You want to do this because that's a free year, right? And in that case, you want time at the end. Typically in like software, we're more interested in getting it granted as fast as possible than what's going to happen 20 years from now. Software changes too quick, but I just wanted to put that up there. So putting it all together, you know, I was telling somebody earlier, yep.
Hi,
Wait.
Casimir. So for startups, when do you suggest to file a provisional? Because startups are always in a crunch, and
Yeah. So I
there's
have
often
that. I have that up there. I was going to get to it. So when do you start? Start in the beginning. I have a client right now, literally right now, that just came to me, and they're going to be. They have $25 million contract. They're going to be in the market in 2 weeks, and their IP is not in place. So obviously earlier than that. The problem, going back to this, is this time frame. And then as I know, you can't enforce it until you get it issued, but that's going to be 3 years from now. So what we have to be doing is planning 18, 24 months ahead of time, trying to do those provisionals, which we can typically do less expensively. We have a program to do it, so that you've got a filing date, you're in the process, and then we can file those utilities fairly quickly. But I'll answer that question in a little more detail too. So what we see, I call it an architecture in kind of medtech healthcare. Everything, there's a device, but the device has software in it, right? To Wendy's point, right? Software as a device, software in a device, almost everything has software in it. It's talking to some kind of app, and then there's some kind of, you know, back end platform that's running AI on it, cranking back out data that you can look at on your app that'll update the device. It's a fairly common architecture we deal with. So at the device level, again, we're trying to get the look and feel, which is the trade dress, well, which is the design patent that we talked about. Trade dress is a form of trademark protection. So I always think of the Coca-Cola bottle. If you see the Coca-Cola bottle across the room, you know it's a Coca-Cola bottle because of the shape. That is trade dress. That's a trademark because I know who made that bottle of soda over there, right? So we want to get those, the function of the device, what's it do? Maybe the design, maybe that's where the IP is. Hey, it does things other devices do, but it does it better. We're able to implement it in a smaller space, or we've added functionality. And then trademarks, right? This one is a 𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏 Same thing, the app. So the look and feel of the app, your UI, we can protect with utility patents, but also design patents and trade dress, right? We don't want people copying your look and feel. And then of course the functions, if any of those algorithms are in the app, how it's output and displayed, right? How that output looks. I just had a client email me last night that we're going to work with kind of an application that's out there, but he's got this unique pinwheel display and navigation, right? We want to protect that. Copyrights in the software, again, trademarks. And then there's that cloud in the back, right? So the algorithms, if there's a portal to get in the back, again, what are the workflows? When I hit that portal, what can I do? Those workflows might be patentable, any look and feel, output display, copyrights in the code. And then of course, if there is a portal functionality, there would be trademarks there too. So we're bringing all of those together. The one I probably left out is trade secrets. So when I talk about copyrights in the code and patenting the functionality, the other IP that comes into play is the trade secret. So we don't put your code in the patent application, right? We're at a much higher level, flowchart kind of architectural level. Your code, though, probably has a lot of know-how in it, right? Because you've made all the mistakes and fixed them, and anybody coming behind you would have to make a lot of the same mistakes, and to some extent. So even though it's easy with code, once you see it implemented, to kind of be like, oh, I can go do that and create something very similar, it's probably not going to be as optimized as yours, right? That optimization stays know-how, stays trade secret, right? We're not putting your code in the patent, right? So there is a little bit of a overlap between the trade secret and the copyrights. Okay, why do we do it? To add value. I mentioned it already. It's that premium pricing, right? We want to, at the end of the day, be able to tell your partners, your investors, hey, if you give me money, you're going to own something exclusively that we can charge extra for, right? We can charge a premium. But it's different. Kind of each stage of the company, you have a different audience that you're presenting to. And how do you know where you are? You got to look at your funding strategy. So, if you're bootstrapping, that's your credit cards, right? You don't really need any IP in place to convince yourself to put 10 grand on your credit card. Friends and family, probably the same thing. They're investing because they love you, not because you're giving them the greatest IP plan. But once you get to here, and certainly by here, you got to have an IP plan, right? Because now you're talking to somebody else you don't know and saying, hey, put your money into my effort. Why would they give you money if they don't get exclusivity, right? Why would I give you 10 million if once I do and you're in the market, somebody else can say, oh, I can do that and go do it, right? You got to have a plan. Angels, it's usually good enough to have those provisionals on file, right? With a plan. Hey, here's what we're trying to protect. Here's the plan. By the time you get here, you got to have the utilities on file, and hopefully maybe even one issued already or allowed. And there are ways. I said it was 2 to 3 years to get through the process. You can pay money, although for startups, that's can be hard to do, but you can pay money to accelerate and make that process go in 12 months. So maybe we want to do that. If you're about to raise Series A, or certainly here, maybe we want to accelerate and get something issued and help you maintain the value that you're seeking. That's really what they do. I've never seen IP, unless it's it is an IP deal, increase the value. Like no one ever said, hey, I'll give you 30 million for the company, or as an investment for part of the company. And then you say, well, look at all this patents I have and all this IP. And they go, you know what? I'm going to give you 35 million. Like that never happens, right? But what will happen is they'll say, I'll give you 30 million. They'll say, show me your IP. If you don't have a compelling story, they go, you know what? I'm only going to give you 25 million. Or I want 45%, not 40, right? That's how it works more. So this is back to that story. When do you start? On the one hand, you don't want to start too early because you only have that 12-month window if you file the provisionals. So if we're too early, we might not have enough detail there. But much more often than not, it's we need to start now. Like I'm pressing my clients saying, hey, we need to go now. Like we got to get those provisionals on file. We got to do it. And like I said, we have programs. It's an investment on our part, but we have programs to try to keep those costs very low at the provisional stage, help you raise someone else's money to then pay for the more expensive steps. Things to note, though, in those early stages, these are areas where you can give away your IP, basically. So right at the beginning, founders agreement. So there's usually a founder, right? But they want to bring in other people, maybe a technical founder. They want to bring in some other people. And so, you get a team of founders. That original founder can easily give away too much too early. You want to be careful here. And you want to make sure that any IP any of the founders come up with goes into the company, right? That's what they're getting their shares in exchange for. Contractor agreements, when you're talking to these gentlemen over here at Aspina, I know that question came up, but you want to make sure that anything you're paying for, you ultimately own with respect to the IP, and that they'll assign it to you. Employee agreements has to be in there. If you're doing a tech transfer, typically this would be out of a university, could be out of another company. You want to look at those agreements, and it's not so much that you won't own the IP. One of the things that comes up, if it's a university, any IP that you build on their IP, they want to own, right? And that's always, you want to have stuff you kind of own free and clear, so you can go to those investors and say, hey, this is ours, that we license. That's one of them. But the other thing that can trip you up is, they want 5%. They don't want it to be dilutable. These types of terms can make you uninvestable. So you got to be careful here. Want to use your non-disclosures agreements. Again, work made for hire. Licenses, you can in-license stuff, and then there's usually, what rights are you really getting? Is it exclusive? Is it exclusive in an area? That kind of thing. You want to make sure you have your rights, have a plan to get IP disclosure so you can go file your provisionals. And then you need a plan overall. And that usually, when I'm preparing these applications, I'm thinking about how am I going to stop someone 3 to 5 years from now from coming into your market and undercutting your premium pricing. But I don't know who they are, and I don't know exactly what they're going to do. But the things I write at the provisional stage has to set the groundwork for me to be able to do that 5 years from now. Yeah, that's a little more art than science. Like you do want to find a good patent attorney to help you out. And where are we? So I don't really have time to go through these, so I'll just mention, but these are, in this space, these are the other things that come up. Corporate practice of medicine, right? So if there's any kind of treatment going on, delivery of medicine, that has to be performed by a doctor, and it has to be performed by that doctor's personal corporation, right? Your company cannot take money for medical treatment. And so if that's the case, if you have something where a doctor has to be present, they have to have their personal corporation, and you have to set up a structure that lets you suck out as much money as you can from that personal corporation to your company that's being invested in, while leaving enough to cover the treatment there. And surprisingly, that is much more art than science. I don't do it personally, but I've had clients pay tens and tens and tens of thousands of dollars to get that set up right. So something to think about up front. Reimbursement, who's going to pay? So a lot of times the companies run in and they say, well, we don't want Medicare, Medi-Cal, people are going to pay for it. It's very, very difficult if you don't have a code to actually get your product paid for, even if your goal is to not have it be done with Medicare. And this actually held up digital health for a long time. There were no codes, and it took a long time to get codes. But so you got to be thinking of that even if you don't want Medicare or Medicaid, you want to have codes for your product. FDA was talked a little bit about, software as a device, software in a device is a huge issue. The problem that wasn't talked about, when you go to FDA, and this held up digital health too, it's end to end. That's what they approve. So in a digital health situation, it's the device, the scale, talking to the router, talking to the, cell tower, other cell tower, server in the back. That's what's approved. You change anything in that chain, you got to go back for FDA approval. That's how it was. Now that AI and ML is in the software, its function is to change all the time. So it creates problems from an FDA perspective. The other issue, if I went to my slide, but I'm going to wrap up here, just get through this list real quick. A lot of device companies are like, oh yeah, we're getting a 510K, right? That's for those that don't know, that's kind of a faster track through the FDA for medical devices. You say my device is just like this device that you previously approved before 1977, I think. The problem is, from your patent perspective, you're saying our device is the newest, greatest thing ever, right? A little contradictory. You want to walk a line, but there was a case recently. I haven't even had a chance to read it in detail. The prior art was their FDA submission, where they said all this stuff is known. Then they combined it with some other reference and said, there's your whole thing, and there's nothing patentable here. So you do want to be careful. The other reason 510K is great, you want to get in the market as fast as possible, as inexpensively as possible. But anyone can follow you, do the same thing, right? So you may want to go for the full approval, because even though that costs money and time, it really sets up a barrier to your competitors because they have to spend the money and time. So the ideal strategy is, what are some things we can get some F510Ks for? And then what are some things, once we're getting money, we can go for the full up approval and make even more money. FTC was mentioned. I'll just say they and the Department of Justice are looking at mergers and acquisitions in this space with aggressive attitude, let's say. HIPAA and data privacy. This is one of the first things after we file the provisionals that our clients need us to counsel them on right now. Data privacy security, not so much HIPAA, although as was mentioned, data, you might have the best here. Doesn't mean you're HIPAA compliant, but it's a start. But it's just such a big issue everywhere, especially in California, of all the states, but it's becoming a federal thing. Selling into hospitals. If you want to sell into a hospital, start now, even if you don't plan to do it for 10 years, because that's about how long it'll take before you get a CIO to say, yeah, we'll buy that. If it's digital health and you say, I got this digital health thing, they'll say, great, tell me how I buy it. Anyone have an answer for that? I don't. I mean, you'd say, well, you tell me, what do you mean? What's your purchasing? No, they're so risk adverse and this stuff is so new. You have to they have to be able to go to their boss and say, there is no way anything would go wrong with this. No way. And then they maybe can buy it. So that's just a big issue. And then this right to repair thing is around the copyrights, my last thing. So this software in a device, software as a device, historically under the copyright laws, no third party can go to your device, access the software and repair it, right? And you don't want that for a variety of reasons. If they change something, is your FDA approval, it's got your trade secrets in it. But there is a proposal, and I don't have the latest status, to eliminate that protection so that these third parties can access your software and repair it. So it's an issue to be aware of. And that's all I have. I think we're out of time. I know we're out of time. But any questions or, yeah. I'll repeat it.
Those who are joining. Thank you.
Yeah, so I have a question about trade secrets. So we know there is a very clear way of protecting general intellectual property, but for trade secrets, what do you typically do? How do you actually protect trade secrets other than NDAs and the other documents?
I mean, that typically is it. I mean, most of our clients don't have, the secret formula, the WD-40 formula, the Coca-Cola formula, right? It's the code, it's the know-how, and you're in all those agreements, your contractor agreements, employee agreements, anyone you're talking to, you're doing an NDA. I mean, that's the way you protect it, but it's usually not something specific like, oh, here's our formula, So, yeah.
So someone come to you say, hey, I have a patent. So how can you tell us quickly? I can search Google patent to know he has a patent or not, right? But that's only for issued patent, right? How about provisional?
So provisionals don't ever publish on their own, but patents worldwide now publish at 18 months from your earliest date, right? So in a provisional, you'll never, once the patent, the utility patent issues, you actually can go back and access the provisional. but they never really publish. But there's an 18-month blackout window. Basically, you don't know what anybody else has done for 18 months. That's you tell them to show it to you. They're going to want an NDA though. Yeah.
You talked about the timing of the provisional patent, and we know that investors like to see traction in the form of patents. So the timing of that, based on funding cycles being so long now, they could eat into that 1 year. What's the best way to maintain your priority date? You know, if you do kind of slip past that 1 year, is it possible?
Yes and no. So there's several strategies. Ideally, we've got the money or we have the wherewithal to just do the utility work and move on. If we don't, we can take what's in the provisional and kind of do no work and just file it as a utility. Probably not the best solution, but like I said, it won't be looked at for 18 to 24 months. So you have 18 to 24 months to kind of clean it up, fix it, and come back and file what's called a continuation in part and claim your priorities. Anything new in that continuation in part, though, will only get the date that it was filed, right? But you preserve it for anything that you had in there. Or if we don't think competitively it'll be a disadvantage, you can just refile the provisionals and start a new year. You lose the year, but start a new year. So was that?
Thank you very much for the presentation. Just have a question. So with ML and AI models right now, there's many different ways to achieve the results. So using different algorithms, different features. One can achieve it with, say, bounding box. Another one can achieve it with segmentation type of model. How do you protect your clients from somebody coming in and using different method or same exact technique?
Yeah. So that's the power of a patent, right? What we're trying to protect in a way is the output, right? What's the function? How you do it, and this is why we don't put the code in the patent applications. How you do it, we don't care about, right? It's what it does that we're trying to protect. And you can't, you know, you can only be so broad, but ideally, yeah, if there's multiple ways to get the same function, we'd have a claim that's broad enough, right? It's directed to the function, not how you did it, right? So, and that's where it gets to be a little more art than science. Like, how do you achieve that, right, with your descriptions and your claims? So,
yeah, excuse me. Hi, Noel. Patrick, I'm the founder and CEO of 𝗂𝗏 Health. We'll be presenting later, but full disclosure, we're a client of Procopio. They do a great job. So, little plug for you. But if Bobby here, if he wanted to start a medtech device company and he wanted to raise a seed round, how much should he budget for IP fees? And then, in addition, you know, some of the subsequent rounds, how much should you put aside?
like $2 million. Yeah, so the provisional stage is usually a few $1,000s, and then to convert those and file that PCT application, maybe another 20,000. Your trademarks, when you get close, a few thousand. Like for the first 18 to 24 months, I would like to have kind of 50,000 budgeted. 35 probably gets us there. But if we, you know, I always end up filing three or four provisionals, three or four utilities at the utility stage. And those become a dozen, 15 patents. Plus you're doing new stuff. Plus we're filing overseas. It does add up into hundreds of thousands, if not $1 million over 10 years, you know? So yeah, it's more about how much do you have to raise for each stage, but 35 to 50 grand early is, I think, probably a must, you know.
This might tie into the future. So after you filed and you did all this, how do you advise people in the future when they're getting challenged, and how can you sort of predict in certain instances that you're going to get challenged, and how do you budget for that? I experienced something many years ago where I had a large corporation sue us. Yeah. We just shut down the operations. Why waste our time and money? But do you give that type of advice? Is there something that, you know, an early stage founder are thinking about of that $1 million or $2 million or $50,000 they're going to have to spend? Thank you.
Okay, and when you say so what typically happens,
you filed the patent and it's being challenged in process and or after by some company that has a lot of money, and they want to eliminate you from the game.
Yeah. So again, I tell my clients, like I said, we're looking at what is going to drive your premium pricing and how do we protect it. The only way to protect it is to sue someone, right? No one's just going to stop because you say, well, I got a patent, you better stop doing, like, you have to sue them. So I'm writing the patents from the provisional stage, preparing to sue those people 3 to 5 years from now, maybe a little longer. If we're not going to do it, don't spend the hundreds of thousands of dollars on the patent because it's wasted, right? I mean, spend it on something else. But yes, when you get to that stage, you know, a patent litigation is going to cost $5 to $10 million. So how do you finance it, right? If there's enough damages, there's people who will fund that litigation. It's a different type of investment. If in that situation, hey, we're going to shut down, but maybe someone would take the case on contingency and go sue that big company if there's enough damages, and then you make your money that way. You know, so there's a lot. There's contingency, there's litigation funding. You know, hopefully you've done it. We've done a good enough job that they're willing to spend 20, 30, 40 million to buy you instead of going to court. It's worth more. So, but that is a, you know, it is a complicated step. How do we use what we've got now?